My name is Nora Ashby. I am 43 years old, and I find things people have hidden. This is, more or less, my job description. I am a forensic accountant. I work for a firm that is retained primarily by corporations and legal teams who need someone to go into the numbers of a situation and find what is actually there, as opposed to what has been arranged to appear there. I trace money the way a hydrologist traces water, not by following the surface, but by understanding where things drain, where they pool, where the absence of something that should be present tells you more than the presence of anything else. I have been doing this for 17 years, and I am, in the considered opinion of my colleagues and clients, very good at it. I tell you this first because the irony of it is central to everything that follows, and I believe in naming irony directly rather than letting it accumulate in the background until it becomes the only thing the room smells like. For 17 years, I found what other people hid. For 17 years, I missed what my own family had done, in plain sight, in the records of a county I drove through twice a year on the way to holiday dinners. The last piece of evidence was a letter. I will get to it. But I want to start at the beginning, because a ledger only makes sense if you read it from the first entry. My grandmother, Eleanor Ashby, was born in 1934 in Calder County, Virginia, the third child of a family that had farmed the same land since before the Civil War. The farm was not large by any agricultural standard, 112 acres of mixed woodland and bottomland, with a creek that ran clear in the dry months and amber in the wet ones, and a house that had been added to and repaired and added to again across a century and a half until it was less a structure than a record. Each addition legible if you knew what you were looking at. The way rings in a cross-section of wood tell you everything about the years the tree lived through. Eleanor had married my grandfather William at 22 and taken his name while keeping, in every way that mattered, the identity of someone whose primary allegiance was to that land. She knew the name of every species of tree on the property, the migration patterns of the birds that stopped in the creek bottom every spring, the particular drainage problem in the lower field that had been there since a flood in 1962 and was managed every season by a specific earthwork that William had built and that my grandmother maintained until she was 78 and no longer physically able to. She knew the soil. She knew the water. She knew the house the way you know something you have lived inside of for 60 years, not as a property, but as a continuous and reciprocal relationship. My grandfather died when I was 9. After that, it was Eleanor and the land, which were, by that point, effectively the same thing. I spent every summer of my childhood at that farm from the age of 6 until I left for college. This is not a nostalgic detail. It is a structural one. The farm is where I learned to pay attention to things other people dismissed as unimportant, the small discrepancies, the things that didn't quite add up, the places where a surface didn't match what was underneath it. Eleanor taught me to notice things. She would walk me across the lower field and point to a place where the grass grew differently and say, "What does that tell you?" And when I looked closely, I would find the buried line of an old fence, or a shift in the soil composition, or the ghost of a drainage channel that had been filled in decades before I was born. The land was full of evidence of everything that had ever happened on it, if you knew how to read it. I wanted, from approximately age 12, to be the person who inherited that farm. Not because of the money. The land was not worth very much by any real estate standard that my father, Martin Ashby, cared about. Because of what it was. Because of what Eleanor and I were to each other in it, which was something I did not have language for as a child and can describe now only as two people who saw the world the same way and found in each other's company the specific ease that comes from being genuinely understood. Eleanor told me when I was 19 and heading to college that the farm would be mine when she was gone. She said it at the kitchen table, over coffee, in the plain declarative voice she used for all important things, the same voice she used to tell me the Latin name of a plant or the history of a property line. "This place knows you," she said. "I want it to go to someone it knows." She had not yet made a will at that point. She was 65 and in good health, and the will was something she intended to handle without urgency. She handled it without urgency. I understood that to mean she would handle it eventually. This is the first place in the story where I should have paid closer attention, and did not. My father is the only child of Eleanor and William Ashby. My mother, Diana, is a woman I have spent 43 years trying to understand with limited success, not because she is complicated exactly, but because the particular architecture of her personality is one that took me a long time to recognize for what it is. She is a woman organized around the management of appearances, what the family looks like, what is said at the right events, who knows what and in what order. She is not cruel in the way of someone who enjoys cruelty. She is practical in a way that functions identically to cruelty when the practical calculation points that direction. I say this having arrived at it slowly, in the way of someone who has finally assembled enough data points to trust the pattern. My brother Wade is 4 years younger than me and has been, for most of his adult life, in a variety of financial difficulties that my parents have been, for most of his adult life, in the process of resolving. Wade is not a bad person. He is a person of limited discipline and considerable charm who has discovered that the charm tends to produce help before the limited discipline produces consequences, and who has arranged his life accordingly. He has, by my rough count, borrowed money from my parents on at least 7 separate occasions, defaulted on a small business loan that my father co-signed, experienced 2 divorces each of which involved legal fees, my parents partially subsidized, and most recently attempted and failed at a restaurant venture in Roanoke that consumed what I estimated at the time, without the full picture, to be a significant sum. I say all of this not to arraign my brother, who did not, as far as I have been able to determine, know the full extent of what was done. I say it because it is the context. It is the pressure that had been accumulating in the financial structure of my parents' lives for 15 years, and that structure is what eventually collapsed in the direction of Eleanor's farm. Eleanor died in March, 3 years ago. She was 88, and she died in her own bed in her own house with the creek running below the window and, by all accounts, without distress. I drove from Richmond the morning I got the call, and arrived in time to sit with her for an hour before she was taken, which is the kind of hour that restructures everything that comes before it. You carry it differently, afterward, than you carried anything that preceded it. The grief was real, and I will not reduce it. Eleanor was the person who had most reliably seen me clearly for my entire life, and losing her was, in a way I was not prepared for even at 40, losing the primary witness to my own existence. You do not understand how much of your sense of self is organized around being known by a specific person until that person is gone, and you have to reckon with the amount of weight they were carrying for you. I turn to the practical things, as I always do in loss, because the practical things are handleable when the emotional things are not. I asked my father about the will. He said there was one, and that it was being handled by the family lawyer, a man named Garrett Sims who had been in practice in Calder County for 40 years and had drawn up documents for half the families in the valley. He said the estate was straightforward. He said I should not worry about it. I should have noticed at this point that he did not say what the will contained. I was grieving, and I was at the farm helping to organize Eleanor's belongings, and the farm was full of her in every room, and I was not, in those weeks, at my analytical best. I accepted straightforward and went back to sorting decades of someone's careful, attentive life into categories. The farm sold in June. I did not find out until October. What happened in between is a period I now have entirely reconstructed, and the reconstruction took me 18 months and the skills I have spent 17 years developing. And I will take you through it because I think every step matters. But what I knew in October was this. I had called my father to ask about the estate resolution because several months had passed and I had heard nothing further. And he said, in the voice of someone managing a disclosure he has been postponing, that the farm had been sold to a developer in June, that the estate had been settled, and that I should have received. And here his voice did a particular thing, a slight adjustment in register that I recognized, in retrospect, as the sound of someone calibrating how much truth to release. A letter about the distribution. I said I had not received a letter. He said he would look into it. He did not look into it. A week passed. I called again. This time, my mother answered, and she said in the voice she uses for conversations she has decided to manage, Nora, sweetheart, this is all very complicated. Estate law is not straightforward. There were debts against the property that had to be addressed. By the time everything was settled, there simply wasn't. And then she said the sentence that I have thought about since, more times than I can count. There wasn't anything left to distribute. I sat with this sentence. I am a forensic accountant. I have spent 17 years sitting with sentences like this one, delivered by people who have decided that the absence of a distribution is self-explanatory, when in fact the absence of a distribution is the most interesting part of any financial narrative. Where did the money go? Is always the question. It is always, without exception, the productive question. I asked my mother the sale price. She said she wasn't sure of the exact number. A woman who had just settled an estate and found nothing left for distribution after the debts were cleared was not sure of the exact sale price. I wrote this down on the notepad I keep beside my phone because I write down things that don't add up, and I said I would find the information through public records, and we ended the call. I found the deed transfer in the Calder County Public Records that evening. 112 acres and improvements, sold to a company called Ridgeline Development Partners LLC, in June of the year Eleanor died, for $422,000. I sat with this number for a long time. Property in Calder County had not appreciated dramatically. It was not that kind of county. But 112 acres with a habitable structure and a creek frontage was not, I knew from general market awareness, worth nothing after debts. I pulled the property tax records going back 10 years. Eleanor's assessed value had been $160,000, which is typically a significant underestimate of market value in Virginia, and the sale at $422,000 confirmed the gap. I then looked for the estate filing. In Virginia, estates above a certain size are probated through the circuit court, and the records are public. I found the Calder County Circuit Court probate filing for the estate of Eleanor Jane Ashby, and I sat in my home office at midnight reading it the way I read every document I encounter professionally. Slowly, entirely, with specific attention to what is present and what is absent. What was present? A will, dated 14 months before Eleanor's death, leaving the real property of the Ashby farm to the estate of Martin Raymond Ashby, my father, with instructions for the proceeds to be used, in the language of the document, to settle the family's obligations and provide for future security. What was absent? My name. What was also absent? Any reference to a prior verbal or documented intention to leave the farm to me. The will had been drawn up by Garrett Sims, my father's family lawyer. I put the document down. I made myself a cup of tea. I am not a person who reacts before I understand what I am reacting to, and I did not yet understand the full shape of what I was looking at. I had a number. 422,000. I had a will, written 14 months before Eleanor's death, leaving the property to my father. I had a gap between the sale price and the nothing that remained after debts, per my mother. I needed to understand the debts. The estate filing included a creditor list. This is standard. Probate requires disclosure of all debts against the estate. I read the creditor list. Eleanor's debts, at the time of her death, consisted of one outstanding utility bill, $312, one property tax arrearage from a missed quarterly payment the previous year, $890, and a personal loan to Martin Raymond Ashby, recorded as a debt of the estate, in the amount of $381,000. I read this 3 times. A personal loan, recorded as a debt of the estate, in the amount of $381,000. My father was the personal representative of the estate, which meant he had both filed the estate and placed himself as a creditor within it, in an amount that, when subtracted from the sale price of $422,000, would leave the estate with approximately $40,000 before fees and the remaining small debts. In my professional life, I have encountered variations of this structure many times. It is a mechanism, not always illegal, depending on documentation, but always worth examining. A family member who is also a personal representative files a personal loan as a debt of the estate. If the loan is real and documented, it is a legitimate creditor claim. If it is not, or if the documentation is fabricated or backdated, it is fraud. I needed to find the loan documentation. This is where the work became what my work always becomes when it is serious. Long, methodical, and organized entirely around the principle that the thing I was looking for would be there if I looked in the right places. Absence of evidence is not evidence of absence. It is a direction for further search. I retained a probate attorney in Richmond named Sylvia Park, who is someone I had worked with professionally on an unrelated matter and trusted entirely. I told her what I had found and what I needed to know. She told me I had standing to contest the estate as an omitted heir if I could demonstrate that Eleanor's intention to leave the farm to me had been documented or that the will had been procured under circumstances that invalidated it. She also told me that the personal loan claim required substantiation, a promissory note, a record of transfer of funds, something that demonstrated the loan was real. She filed for access to the estate documentation. My father, through Garrett Sims, produced a promissory note, a document stating that Eleanor had borrowed $381,000 from Martin Ashby over a period of 12 years for the stated purpose of property maintenance and personal living expenses, and had agreed to repay the sum from her estate upon death. The note was signed in Eleanor's handwriting. It was witnessed by Garrett Sims. I sat with this document. Here is what I knew about Eleanor. She had lived on that farm for 60 years, on the income from a small timber harvest every few years, and the modest Social Security and pension benefits she received after William's death. She had not lived extravagantly. She had lived carefully, the way people do who have calibrated their lives to what they actually have. In 12 years of visiting her, of eating dinner at her table and walking her property with her, I had seen no evidence of significant infusions of cash. The house had been maintained, but not renovated. The equipment was old, but functional. The timber harvests had happened on their regular cycle. I asked Sylvia what we would need to challenge the note. She said, "Bank records showing transfers from my father to Eleanor over the 12-year period. If he had actually lent her $381,000, it would appear as deposits in her bank account. If it had not appeared in her bank account, the loan was not real." Getting Eleanor's bank records required a court order because the estate had been closed. Sylvia filed for it. My father's attorney opposed the filing. The opposition told me something I already suspected, because in my experience, people do not oppose the disclosure of records that support their position. The court ordered the records disclosed. We received them 6 weeks later. In 12 years of the period covered by the promissory note, Eleanor had received from any source consistent with my father's name, account, or associated accounts. The following: $0. There were no deposits consistent with a loan of $381,000. There were, instead, the regular timber harvest payments, the Social Security and pension deposits, and a small number of transfers from an account I did not immediately recognize, totaling, over 12 years, approximately $14,000. I ran the account number on those transfers. It was my account. The transfers were Christmas and birthday gifts I had sent Eleanor over 12 years, automatically, the way you set up recurring payments and stop noticing them. $40 here, $100 there, a larger amount one year when I knew she'd had an unexpected expense. $14,000 across 12 years, in the pattern of a granddaughter who lived 3 hours away and sent money the way she sent attention. Consistently, without fanfare. I put down the bank statement and looked at my ceiling for a long time. Here is what the numbers told me. No loan had been made. The promissory note was fabricated, either in its entirety or in its substance, dressed in Eleanor's signature through a process I would need to understand, but could imagine clearly enough. Garrett Sims had witnessed it. My father had filed it against the estate he controlled. The farm had been sold for $422,000. $381,000 had been removed from that total as a debt repayment to my father. The remainder, after fees, and the small legitimate debts, had gone into my father's estate account, and from there, I would learn this later, primarily to a payment against Wade's restaurant debt and a transfer to a joint account belonging to my parents. The farm that Eleanor had told me would be mine had been sold without my knowledge. The proceeds had been routed to my parents through a fabricated debt. A will had been drawn up 14 months before Eleanor's death, after, I would calculate, my father's financial pressure from Wade's restaurant failure had become acute, that removed my name from any claim. I need to be precise about what I felt when the full shape of this became clear, because the feeling was not what I would have predicted. It was not rage. It was not the particular hot grief of betrayal, which I had expected and which would have been appropriate. It was something colder and more structural, like the feeling I get when an audit reveals a number that is simply, definitively wrong. A flatness, a certainty, the specific emotional register of someone who has looked at the evidence long enough that the evidence has stopped being surprising and become simply what is true. My parents had taken Eleanor's farm. They had done it with a fabricated document, through an attorney who had known my grandmother for 40 years, through a will that had been drawn up while Eleanor was. I would need to establish this, either fully cognizant and persuaded, or not fully cognizant, and therefore not competent to sign. They had told me nothing. They had sold the land Eleanor had said she wanted me to have, the land where I had learned to read the world by reading the ground under my feet, and they had run the proceeds through an estate they controlled and distributed them to themselves and to Wade's debts. I called Sylvia and told her what the bank records showed. She was quiet for a moment. Then she said, "Nora, I want to be straightforward with you. What you're describing, if it's what the evidence shows, is elder financial abuse and estate fraud. These are not civil matters. They're criminal ones. I can continue representing you in the civil contest, but you need to understand that where this goes depends on what we find next and what you want to do with it." I asked what we needed to find next. She said, "Two things. First, anything that corroborates Eleanor's original intention to leave the farm to you. A prior will, a letter, a document of any kind. Second, evidence of when and how the promissory note was created, which may tell us about the will as well. The prior will, if it existed, would have been drawn up by someone other than Garrett Sims, who had clearly been part of what my father had built. Eleanor had, before Garrett Sims entered the picture, used a general practice attorney in the county seat, a woman named Margaret Hollis, who had handled various small legal matters for the family over the years and who had, I learned from the county bar records, retired from practice 6 years ago. I found her through the alumni directory of the University of Virginia Law School, where she had graduated in 1971 and to which she still donated. I called her on a Tuesday morning. I introduced myself and explained briefly what I was trying to understand. There was a pause, and then she said, "I wondered when someone would call." Margaret Hollis had drawn up a will for Eleanor Ashby 9 years ago. In that will, Eleanor had left the farm, all 112 acres, the house, the outbuildings, the timber rights, to her granddaughter, Nora Elizabeth Ashby, with the specific language that the property should remain intact and not be subdivided, because Eleanor had said, according to Margaret's notes from the drafting session, that the land was a whole thing and she wanted it kept whole. Margaret no longer had the physical document. She had returned her client files to the clients upon retirement, standard practice. She had a copy in her own records, she said, but the original would have been given to Eleanor. I asked what had happened to her client files. She said, "Eleanor called me 6 years ago. She said she needed the original back to update some provisions. I sent it to her by certified mail. I have the receipt." 6 years ago, 2 years after my father's financial situation had begun to deteriorate sharply. I did not say this to Margaret. I asked her if she had a copy. She did. She mailed it to Sylvia. We received it 10 days later, and I drove to Richmond to read it in Sylvia's conference room, because I did not trust myself to read it alone. The will was real. The will left the farm to me, entirely, with Eleanor's clear language about keeping it whole. The will had been signed and witnessed properly 9 years ago in Margaret Hollis's office. This meant there were two wills, the one Margaret had drawn up, which left the farm to me, and the one Garrett Sims had drawn up 14 months before Eleanor's death, which left it to my father's estate. Under Virginia law, the later will supersedes the earlier one, provided it was executed validly. The question was whether it had been. Sylvia retained a handwriting expert to examine Eleanor's signature on the Garrett Sims will and on the Garrett Sims promissory note, compared against known exemplars of Eleanor's signature from the last 3 years of her life, documents from the county extension office, from the timber company, from her own financial records. The analysis took 5 weeks. The conclusion was probabilistic but significant. The signatures on both the will and the promissory note showed characteristics inconsistent with known exemplars from the same period, specifically in the fine motor control of the terminal strokes, which the expert noted could indicate either forgery or significant cognitive or physical decline. Significant cognitive or physical decline. I requested Eleanor's medical records from her primary care physician in Calder County. This required another court order. We received the records. They showed that Eleanor's physician had documented, in the period 18 months to 12 months before her death, which overlapped with the period during which the Garrett Sims will was signed. Concerns about increasing confusion and difficulty following complex conversations. The physician had recommended a cognitive evaluation. There was no record that the evaluation had taken place. Eleanor had been declining when she signed that will, or someone had signed it for her. I now had a prior valid will leaving the farm to me, a subsequent will of questionable execution leaving it to my father, a fabricated promissory note filed against the estate, a complete absence of any bank records supporting the loan, a handwriting analysis raising questions about the signatures, and medical records documenting cognitive decline in the relevant period. Sylvia said, "I need to ask you something before we go further. This material, assembled, is enough to refer to the Commonwealth's attorney for a criminal investigation. That means your father and likely Garrett Sims are looking at prosecution for elder financial abuse and potentially fraud." I want you to know what you're deciding if you decide to proceed. I looked at the documents assembled on the conference room table. The prior will, Eleanor's handwriting in it, 9 years ago, strong and clear and exactly like herself. The sentence about keeping the land whole. I thought about Eleanor at the kitchen table, telling me this place knows you. I thought about the lower field and the old fence line and the ghost of the drainage channel. I thought about 112 acres now in the possession of a developer who would subdivide it exactly the way Eleanor had spent her life, making sure it would not be. I thought about my father, who had called me on a Tuesday to tell me the estate was settled, in the voice of a man calibrating a disclosure. Proceed, I said. The Commonwealth's attorney for Calder County is a woman named Deborah Sattler, and she received Sylvia's referral with the attention of someone who has seen financial elder abuse before and found it, each time, specifically and personally offensive. She opened a formal investigation. She was not able to share the investigation's progress with me in detail, and I did not ask her to, because I had made my referral, and my role in the matter was substantially complete. I had found what there was to find. What happened to it next was the legal system's work, not mine. What happened was this. Garrett Sims, confronted with the bank records and the handwriting analysis and the medical records, retained a criminal defense attorney within 48 hours of the initial investigative contact, which is not what an innocent man does. He subsequently provided testimony in exchange for a reduced charge that implicated my father as the initiating party of the scheme. He attested that my father had come to him with the idea for the promissory note, that he had drawn up the Garrett Sims will at my father's direction, and that Eleanor, at the time of signing, had required the provisions to be explained to her multiple times, and had at one point, during the signing, asked where her granddaughter Nora was. She had asked where I was, while signing a will that removed me from the farm I was supposed to inherit. I will say only this about that detail, and then I will move on, because it is not the kind of thing I can discuss at length in the calm register I am trying to maintain. Eleanor asked for me, and I was not there. And I was not there because nobody told me there was anything to be there for. And she signed anyway because she was 86, and declining and alone with two men she had been given reason to trust. And the fact that I was not there is the wound underneath everything else in this story, the one that the legal outcome does not touch. My father was charged with elder financial abuse and estate fraud. He entered a plea that involved restitution and a suspended sentence, the details of which are not mine to disclose. Garrett Sims lost his law license. The estate was reopened. The developer who had purchased the farm was not implicated in any wrongdoing. He had bought in good faith. And the land was legally his. The land could not be recovered. Eleanor's explicit wish, to keep it whole, had already been violated. The farm was already divided into parcels on a plat map in the county assessor's office, and the house was either already demolished or in the process of being so. I received a restitution payment. It was not the farm. No payment is the farm. I want to tell you about the last piece of evidence, because I named it in the beginning, and I have not yet told you what it was, and I think it is the most important thing in the story. Toward the end of the investigation, Sylvia received a communication from the property management company that had cleared Eleanor's house after the sale. Standard procedure. When a property is purchased and a house is cleared, abandoned items are typically photographed and cataloged before disposal, in case of subsequent legal claims. The company had a box of items from Eleanor's house that had been flagged during clearing because they appeared to be personal documents rather than household debris, and which had been held in storage on the off chance someone claimed them. Sylvia had subpoenaed anything from the estate that might be relevant, and this box fell under that subpoena. The box arrived at Sylvia's office while I was in Richmond for a meeting. She called me and asked if I could come by. The box contained several years of farm records, Eleanor's address book, a collection of seed catalogs going back to the 1990s, a packet of letters from my grandfather written during his military service in Korea, and a sealed envelope addressed, in Eleanor's handwriting, in the strong, clear handwriting of someone whose fine motor control was entirely intact, in a date 8 years ago, before any of this began, for Nora, to be opened when the farm is hers. Eleanor had written that envelope 2 years before the decline, 2 years before my father had begun arranging what he arranged. She had written it when she was entirely herself, and she had put it with her documents, and it had survived the clearing of the house and the storage box and the subpoena, and sat on a conference room table in Richmond while I held it for a long moment before opening it. The letter was 4 pages, in Eleanor's handwriting. She wrote about the farm, not sentimentally, but specifically, the way she spoke about everything. The drainage problem in the lower field and the specific earthwork solution. The timber stand on the north ridge that was ready for harvest in approximately 12 years. The section of the creek bank that needed reinforcing every 3 years or it would erode. She wrote about the house, the addition her grandfather had built in 1923, and how you could tell it from the original by the slightly different pitch of the roofline, the root cellar under the kitchen that most people didn't know was there. She wrote about the birds. She wrote about the soil. And then, at the end, she wrote this. I have known since you were 9 years old, the summer you walked the lower field with me and found the old fence line without me telling you where to look, that you were the one who understood this place the way I understand it, not as a property, as a living thing that you have a responsibility to. I have tried to make sure it comes to you legally and clearly and without difficulty. I do not know what the world will look like when you read this, but I know what I intend, and I want you to have it in my own words in case the world makes things difficult, as the world sometimes does. The land knows you, Nora. You have always known how to read it. That is not something anyone can take from you, even if they take the land. I sat in Sylvia's conference room and read this letter twice, and then I sat with it for what was probably 15 minutes, without speaking, while Sylvia found somewhere else to be. The letter had not changed the legal outcome. The land was gone. The restitution was money, and money is not 112 acres on a creek in Calder County. But Eleanor had known. She had written it down, clearly and early, in her own hand, in a letter she had sealed and addressed to me, against the possibility that the world would make things difficult. She had taken the measurement of what might happen, and she had left me evidence of what she actually intended, and the evidence had waited in a box in a storage facility and made its way, eventually, to a conference room table where I could finally read it. I folded the letter and put it in my bag. It is in my desk drawer at home now, with the 2 other things I keep there. Her seed catalog from 1994, which was in the box, and a small sketch I made as a child of the lower field, with the fence line marked in pencil. My father and I have not spoken since the investigation concluded, which was 8 months ago. My mother has called twice. The calls I have let go to voicemail, because the voicemails contain the version of events she has constructed for herself. The one in which circumstances were more complicated than I understand, and he was under enormous pressure and family is family. I have listened to both voicemails. I have not returned them. I will not. Yet. Perhaps I will eventually, when I have decided what a conversation with her would actually be for, and what I would need it to contain to be worth having. Wade called once. He knew less than I had assumed. My parents had told him only that the estate had been complicated and that the farm had been sold at some point after Eleanor died. He had not known about the note, about the will, about the investigation, until the investigation became a matter of county record and someone who knew him happened to mention it. He was on the phone for a long time, and the quality of his silence in the gaps was the specific silence of someone assembling information they hadn't had before and finding the assembled picture very bad. At the end of the call, he said, Nora, I'm sorry. I don't know what else to say. I told him I believed him, which I did. I told him there was nothing required of him except honesty if questions arose later, which I thought there might be. He said he understood. I went to Calder County in September. The farm had been partially developed. 2 of the 4 parcels had been cleared and had road grading visible. The 3rd parcel still had its timber, though it was staked with survey flags. The 4th parcel, the one with the house, was a foundation and a chimney, and the roofline of the 1923 addition, which had not yet been demolished, standing alone above the cleared space the way things do when everything around them has been removed, and they have not yet understood they are no longer part of a larger whole. The creek was still there. The creek will be there for a very long time after everything else is gone. I walked to it. I stood in it, in my rubber boots, the way Eleanor and I had stood in it dozens of times over the summers of my childhood, and I looked at the water and at the amber it was turning in the late season light, and I took a measurement the way Eleanor had taught me. I let myself look at what was actually there without adjusting the reading for what I would have preferred to find. What was there? The creek, still running. The timber on the north ridge, untouched, exactly where Eleanor said it would be. The soil, which did not know anything about developers or probate courts or fabricated promissory notes, and was simply the soil, continuous and patient, doing what it had been doing for considerably longer than any of us had been around to have opinions about it. What was not there? The house, the relationship intact, the outcome Eleanor had wanted. Both of these things were true at the same time. I have learned in my work and in my life that this is always the condition of an accurate reading. It contains both what is present and what is absent, and the integrity of the reading depends on not looking away from either. I have been offered, since the restitution was paid, several opportunities to speak publicly about elder financial abuse, organizations that work on the issue, legal reform advocates, a journalist who wants to write about the intersection of estate law and family exploitation. I have agreed to some of this, carefully, in the specific cases where I believe my account of the mechanics of the fraud might be useful to people in similar situations. Not because I believe my story is exemplary or particularly dramatic. It is, unfortunately, common, and there are families every year in every county who face variations of the same scheme with fewer tools to address it. But because Eleanor's letter said the land knows you, and what I know about land is that it carries evidence of everything that has ever happened on it, and the evidence is readable if you know how to look. Eleanor taught me to look, the thing they could not take from me, and she had known this, in the same letter where she named everything else, is that I know how to look. I have bought a small property in the valley. Not in Calder County. I am not ready for Calder County to be a place I live rather than a place I visit, and perhaps I will never be. But in the same general region, the same topography, the same creek bottom ecology that Eleanor walked me through over 30 summers. It is 11 acres, not 112, and the house on it needs more work than I have yet done on it, but the soil is what I know, and the creek runs clear in dry months and amber in wet ones, and in the spring the birds come through the bottom in the same patterns they have always come, indifferent to property lines, following the water the way they always have. I walk the land on weekends. I take samples from the creek when I want to understand something about the upstream conditions. I have found, already, the ghost of an old fence line in the east field, the kind you only see when the grass grows differently over the buried wire. I crouched down and looked at it the first time I found it. What does that tell you? It tells me everything that was ever here is still here, in one form or another, waiting to be read by someone who knows how to look. I know how to look. Eleanor made sure of that long before anyone had a reason to wish she hadn't.